All right, let's dive into a topic that gets right to the heart of workers' rights here in the UK, unfair dismissal. Now, I know it can sound like a really complex legal minefield, but figuring it out is so important for pretty much everyone. So let's get straight to it and demystify the whole thing.
I mean, it's a situation a lot of us can imagine, right? You're let go from your job, and the reason they give you, it just doesn't sit right. It feels flimsy or maybe just completely unfair. Well, that feeling is exactly why this area of the law exists, to give you a way to challenge that decision.
But, and this is a huge but, before you can even get your foot in the door to make a claim, there's this massive hurdle. As it stands today, most employees need to have worked for their employer for 2 continuous years just to get the right to claim unfair dismissal. This 2-year rule is a massive point of contention, and you'll see why in a little bit.
So, to get our heads around all this, here's our game plan for today. We're going to start with the fundamental right to a fair firing itself. Then, we'll look at the tests that employers have to pass. We'll dig into why the how of a dismissal is so critical, cover the absolute deal breakers, and then we'll look at some potentially huge changes coming down the pike.
Okay, so first up, where does this right actually come from? Because this isn't just some nice idea or a company handbook rule. Nope, this right is properly baked into UK law, and it's the foundation for every single unfair dismissal case.
And here it is, the big one. Section 94 of the Employment Rights Act of 1996. It's a simple sentence, but it's the bedrock of everything. It creates what's called a statutory right. That basically just means it's a formal legal protection passed by Parliament. Of course, that little word eligible is doing a lot of work there, which for now brings us right back to that 2-year rule.
Right, so let's say an eligible employee is dismissed and decides to make a claim. The tables turn, and suddenly the pressure is all on the employer. They have to prove to a tribunal that the dismissal was fair, and to do that, they have to clear 2 major hurdles. Let's break down this test. So the first hurdle for the employer is proving they had a legit reason for letting the person go. And the law is pretty specific here. It only recognizes these 5 potentially fair reasons. The employer has to be able to shoehorn their reason into one of these 5 boxes.
First up, we have capability. This is all about whether you can actually do the job you were hired for, so your performance, your skills, or even your health. But what's key here is that a case involving an employee named Briggs showed you can't just say you're not good enough and fire someone. An employer has to give warnings and a real chance to improve. The process is everything.
Next is conduct. This covers all sorts of misbehavior, from always being late to something way more serious. But here's the thing. The punishment has to fit the crime. A classic example of this was a case where an employee, C. Smith, made a critical post on social media. The tribunal decided that, yeah, it wasn't great, but it wasn't serious enough to justify immediate dismissal. So the firing was unfair. Third on the list, redundancy. This is when a business's needs change and your specific job just isn't needed anymore. But a fascinating case involving the Zyka restaurant really highlights a running theme here. Even with a totally valid reason for redundancy, the dismissal was still found to be unfair because the restaurant completely failed to follow a fair process like consulting properly. And the last 2 are a bit more niche. Statutory restriction means it would actually be illegal for the employer to keep you on. Think of a delivery driver who loses their driving license. And some other substantial reason, SOSR for short, is basically the catch-all category for other legit business needs that don't quite fit anywhere else.
Okay, let's move on to the second part of the test. And honestly, this is where it gets really interesting. Because even if an employer has a fair reason, they also have to prove they acted reasonably in deciding to dismiss the employee for that reason. This is where most employers trip up.
And to figure this out, the tribunal uses this brilliant legal idea called the band of reasonable responses. The court isn't asking if we were the boss, would we have fired this person? No. It asks, for an employer of this size and with these resources, was the decision to fire them within the range of responses a reasonable employer might have taken? It's a test of reasonableness, not perfection.
And this quote, which comes from a famous legal principle, just nails it. It confirms that the procedure is absolutely critical. Doing things like a proper investigation, holding a disciplinary hearing, allowing the employee to appeal, these aren't just optional extras. Skipping these steps will almost always make a dismissal unfair.
So now we're moving into the absolute non-negotiables. There are some reasons for firing someone that are considered so unacceptable that if an employer does it, the dismissal is automatically unfair. Full stop. And in these cases, that 2-year service requirement we talked about, it usually goes right out the window. Here are some of the big ones.
If you're dismissed for being a whistleblower, or for a discriminatory reason like your race or gender, or because you're pregnant, it's automatically unfair. These are legally protected activities, and the law puts an extra strong shield around them.
All right, here's a bit of a mind-bender for you. What if things at work get so bad, so unbearable, that you feel like you have absolutely no choice but to hand in your notice? Can you actually quit your job and still claim you were dismissed?
And the answer is a big yes. It's called constructive dismissal. This is what happens when your employer's actions are so bad that they've seriously broken the terms of your employment contract, like completely destroying all trust and confidence. If you resign because of that breach, the law says you didn't quit, you were pushed. It treats your resignation as a dismissal.
So, that's the lay of the land right now. But what if I told you all of this could be about to change, and I mean radically change? Let's take a look at the proposed Employment Rights Bill and what it could mean for the future of work in the UK.
This right here is the headline act, the absolute game changer. The bill proposes to completely scrap that 2-year qualifying period we've been talking about. Look at this. We would go from a 2-year wait to having the right not to be unfairly dismissed from day one. That is a seismic shift.
But it doesn't stop there. To try and balance out this new day one right, the bill also suggests bringing in a formal probation period with simpler dismissal rules. It also wants to make the controversial practice of fire and rehire automatically unfair and give more security to people on 0-hour contracts.
And this really brings us full circle. This is what employment law is all about, isn't it? It's a constant balancing act. It's about protecting workers from being treated unfairly while also making sure businesses have the flexibility they need to actually function and grow. This bill is just the latest attempt to tweak that balance.
Which leaves us with the million-dollar question, doesn't it? As we look to the future, will giving millions more people these rights from day one lead to a genuinely fairer workplace for everyone? Or will it just create a whole new set of headaches and uncertainties for businesses? It's a huge debate, and honestly, the jury is still out.